First time I've ever tried this with a tripod. It is not perfectly balanced, but I think that might be the best I can do for now. So, we are here at Washington Union Station. Behind me, there is a little bit of a protest going on. This is the 24-hour veterans protest. Over there, there are the tents set up, but there's a small group of people set up right at the base of those flags, and that's just sort of going on 24 hours a day. I've been checking in regularly and posting those lives to just sort of show you guys what's going on there. Excuse me. But today, I'm going to sit here for a little bit and go through a recent case while we're here, because it's kind of a quiet day. It's just not a ton going on. And it's funny because, over this weekend, I did not come down. Not intentionally, but I was busy. And all these videos were coming out from Union Station. All of this crazy stuff happening here. That plaza behind me, that brick you can see on the ground, there were several very large military vehicles set up there. It looked pretty crazy. And so I came back down today thinking those vehicles were going to be here. It was going to still be sort of this big presence. And I have not seen, of every time I've come down here since the National Guard showed up, I have not seen a single member of the military today, which is odd. It's just new and different. So one of my goals here has not been to sort of control the narrative of what I'm broadcasting, but to kind of give you these long, frankly boring videos where you get to see for yourself and define your own narrative based on what you see. And I have to freely admit that I missed the weekend when the exciting stuff happened. And I don't think that was an accident. I think that, there were going to be more people here, and not only did the protesters want more people to see that, but the federal government, who were sending the military here, wanted more people to see that as well, and they were going to over the weekend. So they made themselves everybody made themselves well known over this weekend. Today, it's not the weekend, nobody was going to see anything, and so nobody's here. Now, like I said, the protesters are here. They're here 24 hours a day, they have tents set up, they're not going anywhere. But I have not seen anybody from the military anywhere. I went through the building. Again, that does not mean they are not here. It just means I couldn't find them. And I would at least like to point out that normally I have at least seen them. So make of that whatever you want. That is for, you to determine. I may happen to have shown up during a lunch break, but I can see what I can see, right? So that being said, this is what's happening right now. I've left this in the background so that you can sort of see what's happening back there. And I am going to talk through for a minute, if I can find it. Where did I put it? Here it is. Couple of these cases. Now later today, I'm probably going to come back and talk about this new case that was just filed in Washington, D.C. Attorney General just filed a new case related to the military presence here. And unfortunately, I found out about that just as I arrived here. So I didn't have a chance to print it out and bring it with me. Otherwise, I would be talking to you about that because it's a little more topical. Instead, I'm going to go through some of the high points. I wanted to bring up a couple of things that came up in the new tariff case. Now, I don't know how many of you were listening when the first part of the tariff case came out, but one of the kind of most important things about this tariff case is that there were kind of two, according to the court, there were sort of two groups of tariffs. You had one group that was about, that applied to 3 different countries: Canada, Mexico, and China. And that was about sort of bad, I'll say, chemicals and bad people coming into the country. And in that group of tariffs, the president declared an emergency about those people and chemicals crossing the border and blamed the countries of Mexico and Canada for not keeping the border security higher, and China for not protecting the imports better. And so there's that one group of tariffs, and he says, I am going to impose these tariffs to sort of pressure these three countries into making sure that these bad people and these bad chemicals do not cross the border into our country. So that was group one. And then there's group two, which is a totally different set of tariffs that was about sort of balancing trade imbalances. It was, things cost less when we buy them from some of these countries, and so Americans are buying these products instead of American products, and so we need to make them more expensive so that people will buy American products instead. Trade imbalance or whatever, or we're buying more of theirs than they're buying of ours, or different theories on trade imbalances, whatever. And frankly, I'm not an economist, so I probably shouldn't even fully explain what that means to anybody, because I'm probably not going to do it right. But let's say group two is all about trade imbalances. And so both the district court really made a big deal. That was back in, I want to say June or right at the end of May. District court made a really big deal about evaluating the first group of tariffs, the tariffs that were about bad people and bad chemicals crossing the border, again, only applying to China, Mexico, and Canada as one set of tariffs, and the other set of tariffs, the one about trade imbalances, differently. They had two completely different evaluations for the two of them. They were like, these two groups of tariffs are just so different, it's almost like two different cases, and so that's kind of how they looked at them. And in the appeal that just came out a couple of days ago, they do the same thing, but they kind of, I'm going to say, presume that you read the other case, because the other case went into such detail. I mean, pages and pages of detail explaining the difference between these two groups of tariffs. And I didn't feel like this appeal did that so much, but they still sort of presumed that you understood it. So, different situation, or different way of looking, but you kind of had to have sort of known that, I think, to understand that. They still relied on these as sort of two different groups of tariffs. And the important thing here is that when the president wrote the tariffs, when the president created the tariffs, he didn't treat them as though they were different. He looked at these two different problems. One problem, the bad people and bad chemicals crossing our border. The other problem, the trade imbalance. And he declared emergencies about both of them, and then used his emergency tariff power to fix the problems. That's how he did it. So it's not a question of whether he used some other power that he had, because he said, I am declaring an emergency and I am imposing a tariff under my emergency power to fix these emergencies. So that's all the court had to evaluate. Other theories that people will talk about, like, oh, well, maybe he could have used this power or that power. Fine, he could have, but he didn't. So those are kind of not going to be discussed by the court because they weren't actually used. Even if they could have been, they weren't. So the court's going to stick to what was actually used in these cases. We're going to start with the first one, which is the Canadian, Mexican, Chinese tariffs, which are related to that first situation, bad people, bad chemicals crossing the border, and blames those three countries for not doing enough to stop those bad people and bad chemicals from crossing our borders. And what the lower court, what the district court said about this, is that the emergency power allows the president to impose a tariff that will fix a declared emergency. And I can't think I had a good example of this, but the problem here that the lower court had is that what he was doing was imposing a tariff as leverage to force somebody else to fix the emergency. And that was not what the language of the law allowed him to do. It was supposed to fix it directly. It only gave him this very limited power, this rarely used power in the rare occurrence that he could use it to directly fix a problem, not to force somebody else to fix the problem. And that is what he was doing. Not hypothetically, but explicitly. It's what he said he was doing. So that was the problem with the first group. The second group, the problem was that there is a totally different set of laws related to dealing with tariffs for trade imbalances. There is a law out there for the president to adjust tariffs when there's a trade imbalance. There's it's a totally different law. It's not that emergency power, it's the trade imbalance power. And he didn't use the trade imbalance power, he used the emergency power, and the court said, well, you can't do that because the emergency power says you can only use this when there is not another tariff power that you could be using. And there is explicitly another, a perfectly named, not really, Trade Imbalance Act or something that you could have been using for this that was much more appropriate. And the emergency power says, if there's something more appropriate, you're not allowed to use this. This is a very narrow, rarely used power that you're only given once in a very, very blue moon when the stars line up just right. And the stars have not lined up just right this time. You should have used this other power. But the thing is, the reason he didn't use that other power is that it's hard to use, and it doesn't give you that much power. It only kind of allows you to like tweak things a little bit, give you a little wiggle room, make a little bit of change, but not, the 25% tariffs against everybody in the world sort of changes that he imposed. So it wouldn't have let him do that anyway. So that's why he didn't use that power. He used the emergency power that was much broader, kind of just said, do whatever you need if there's an emergency, but it had to be an emergency. Trade imbalances happen. That was the other thing is that the district court said, is that trade imbalances happen all the time. Emergencies happen rarely. Emergencies are unexpected and happen once when you don't see them coming. That's what makes an emergency an emergency. Trade imbalances happen every other week. So that's not what this other law is for. That's what the trade imbalance law is for fixing that. So, but that was the district court. That was the lower court. That's how they dealt with this. So the Court of Appeals comes along to reevaluate that lower court decision and make their own decision. But here's the thing. You get back to, let's see, where are we? There's something called a standard of review, which tells the appeals court exactly how they're supposed to evaluate this lower court decision in this case and determine whether or not it should stand or not. And I could go off on standards of review for days. I did a video on the standards of review, like the classic 3 standards of review, but those are for evaluating the ones we think about the most. There are so many standards of review for different situations and different things, and it's all over the place. The standard of review in this case, I will look at, fortunately, it is very short. This is the entire paragraph on standards of, this is the entire section on standards on the standard of review, because it's a pretty easy evaluation in this case. So we review the lower court's grant, because the lower court can grant an injunction, and when you do that, we review a grant of summary judgment de novo, which means the lower court granted a summary judgment. They said final judgment based on the paperwork, basically. We evaluate that de novo in this case, which means we start over again as if they'd never said anything and evaluate it fresh. So that part of their decision we're going to review with fresh eyes. We're going to look through it and decide for ourselves. The injunction that they applied, we're going to review for an abuse of discretion. Now, this is a little silly. This is a little bit of courtroom silliness, I will admit, a little bit of legalese silliness, because we have now instituted an injunction which stops them temporarily and a summary judgment which stops them permanently. So why do we have to review both of them individually? I don't know. But ironically, we are going to review the injunction, the first one, with a less intense eye than the second one, which I guess makes sense. But the second one we're just going to look at with an abuse of discretion. Did they abuse their discretion as a court when they instituted this injunction? That is the only thing. So an abuse of discretion is established by showing they made a clear error in judgment. That is part of the standard of review. In weighing the relevant factors, so there were a bunch of factors they had to go through. Did they make a clear error in judgment in weighing them? Or did they exercise their discretion based on an error of law? Did they read the law wrong? Or clearly erroneous facts? Now, the thing is, the appeals court can very rarely review facts. Things that were decided, what color the car was, that kind of thing. But if it was clearly erroneous, like so wrong, then sometimes they are, and here they're allowed to review it for clearly erroneous. So if the court decided that the car was blue and it was actually a bicycle, clearly erroneous. If the court decided that the car was blue and it was actually kind of a aquamarine, no, that's not clearly erroneous. That's a difference of opinion. So clearly erroneous is the standard. To the extent the lower court's decision to grant or deny an injunction hinges on questions of law, then this court will review those determinations without deference, which means that if it's a question of law, if it's actually like, was this law read correctly, then this court, because they're a higher court, they're a court of appeals, they are not going to give any benefit of the doubt to the lower court. They're going to make their own decisions here, but only on questions of law. So that's the standard of review here. But I'm going to say it only sort of matters, because they're going to use that really nuanced standard of review on the injunction and then read the summary judgment as if nothing had ever happened before, do it totally fresh. So, but standards of review it's like its own body of law, and I find it kind of interesting. So, and just knowing that it exists, I think, is important. Okay, so the point is that they're gonna be going through a lot of this stuff fresh, and so they're gonna have to determine, of course, whether or not the court was allowed to hear it in the first place, which they're gonna do, and they're gonna find that it was. Let's see here. I'm gonna jump forward a little bit. So here is part of the questions that they're going to look at. There are a few different laws, and they're going to look back at the history of how these laws developed, because there are these emergency powers that are given to the president, and this is here we're talking about this one set of tariffs, that set of tariffs that were more about China, Canada, etc. that's a little bit more talking about those, because I think in the end they're going to also make this division between the two, but they're looking at these de novo. They're looking at these with fresh eyes. So if they decide they want to throw them all in together, whatever, but they're going to evaluate these emergency powers. So they're going to go through kind of the history of all of this stuff and see how it developed over time. Because some of these laws said one thing, and when they weren't working well, they were changed or new laws were written. And so that is pretty good evidence that Congress kind of intentionally wanted to do something. You know, if the president had really broad powers at one point, and he tried to use them, and Congress said, and so they wrote a new law that was much more narrow, that's a pretty good indication that it was Congress's intent to narrow the powers of the president. And that is actually what happened in this case. And so they're going to look through how these laws developed over time, over 100 years, and sort of determine that that Congress really intentionally narrowed the president's power, because they didn't want this to be this freely usable power that he could just do anything he wanted with. So we look at the Tariff Act of 1930, which allowed the president to specify and declare new or additional duties. So that's a pretty broad power, right? Oh, and by the way, I skipped a very key point here, which is in the Constitution, tariffs are a congressional power, 100%. They belong to Congress. So the only time the president is going to be able to even touch them is when Congress explicitly says, hey, you can go ahead and use, you can use our power to do this. But generally, when they do that, they're going to do it in a very limited way. They're not just going to say, we don't want this anymore, you can have it. They're going to say, hey, if an emergency comes up and we don't have time to deal with it, then you can go ahead and do this. And so that's what's going on here. So Congress has set, as part of this, and I'm trying to see if it's the Tariff Act of 1930 or one that came soon after that, but Congress did set sort of a, let's see here, a table of tariffs. They kind of set a table of tariffs. They don't always adjust it, but they do generally allow the president to adjust it a little. And that kind of started early. I'm going to see here. The Trade Act allows the president to impose duty or other import restrictions, but that was as of 1930. So and then we have the series of court cases where the court kind of narrows this stuff. And over time, I think generally as the president tries to use these more, Congress kind of pulls them back. So Section 232 does not allows him to adjust, which the government argues is a synonym for regulate. But the Supreme Court, said neither the term duties nor any of its synonyms appear anywhere in the IEEPA, which is the emergency power. So the history lacks any power within the emergency power to adjust. Yeah, I jumped to the wrong spot. Sorry, guys. I think I went a little far. Oh, yeah, I did. Let me pull back a bit. That's subject matter jurisdiction. Yeah, I see why. It's because they did it in a weird order. So let's see. Basically, the idea is that as they go through, they keep narrowing and narrowing this power, and particularly We're talking about the major questions doctrine, which is something I'll tell you about in a minute. The big thing is that there was one particular spot where the president was given the opportunity, was kind of given the power to make changes, and there was a case. It was Yoshida 2, and this is there were a couple of Yoshida cases that happened in the 1970s, and this is, as they're narrowing this power down, the president does have one power to impose. He uses to impose these tariffs, but what he does. We have had at that point the tariff had been set by Congress at this level, but we had a special agreement with that country that lowered the tariff to here. And the president, as part of his emergency power, as we were going to having some sort of a conflict, he kind of canceled that agreement and raised the tariff up, but not as high as Congress had set it. And that was kind of the one time that the court said he had really used that power and was really within his own abilities to use that power, because he had never passed what Congress had set. And so that was kind of an important distinction between the other times that he'd used it. So that's one of the things that the appeals court kind of talks about. Again, they go through a lot of these steps, but I've kind of lost the spot in here where they do it. I think it's sort of spread out, so I'm going to jump over that. The one other thing that they really get into, which I think is kind of important, is the major questions doctrine, which is, I kind of hate the major questions doctrine. I think it's a cop-out, but major questions doctrine, I think it's a cop-out. Whatever. So the major questions doctrine says that whenever the president claims a new power, something he's never claimed before, whenever the president claims a new power, it has to be very, very explicit. So if Congress gave him this much power and he's only ever used this much and he wants to go into this area, then the part over here needs to be written out very clearly the first time he uses it. And so that is called the major questions doctrine. When it's a really major expansion of presidential power, he needs to really stick to the language, and he has not stuck to the language here. And so then they're going to go through this kind of very extensive review of kind of what the power had meant in the past versus what it was here. So words like, the question is that the power that he claims he has to do this is to regulate trade. And they're saying, well, regulate does not include what you're saying here. Other verbs implicate the common law doctrine that trade with enemy nations or hostile actors is illegal. These measures are more readily understood to fall under authorization to regulate an importation. So there are other things that would mean, that regulate would mean, but not adjusting tariffs. So under the major questions doctrine, a power never previously claimed would be implicated. And the tariffs at issue in this case implicate the concerns as they are both unheralded and transformative. And so this brings in the major questions doctrine, and he needs to stick to the stick to the letter of the law, which he's not doing, according to this Court of Appeals decision. So the way that the president has used this law, this IEEPA, this emergency law before, is to freeze assets, to block financial transfers, embargoes, or impose targeted sanctions. Even under the TWEA, which is the earlier law, the one that was a little bit broader, that got narrowed later because the president was kind of overusing it a little bit. On only one occasion were tariffs used, and that was the case where he moved them up to the level that they were set by Congress because they'd been lowered by a special treaty. And he went in and said, we're at war with these guys, so I'm going to raise them, but not as high as Congress had set them already. So they're saying that's not a use of the tariff power because he's not using it to go past what Congress had set the tariffs at. The executive's use of tariff qualifies as a decision of vast economic and political significance, so the government must point to a clear congressional authorization for its interpretation of this Emergency Powers Act. We discern no clear congressional authorization for tariffs of the magnitude that's being used. Reading the phrase to regulate importation to include imposing these tariffs is a wafer-thin reed on which to rest such sweeping power. So that is one of the big points that the court makes here. And then they're going to go into this Yoshida 2 case, which is that other guy. Let's see here. But they also point out that Yoshida 2 is not binding on the en banc court, but whatever. So generally the idea is that there was one law called the TWEA. It was an emergency act that gave the president really broad powers, and President Nixon tried to use it, and Congress was like, we don't like, no, you're overusing this. And so they wrote this new one, the IEEPA, that was smaller. And so that's what's in place now, and that is what the president relied on. And I forget, the TWEA is still there, but it can only be used in much more narrow circumstances. I think, I think that the TWEA is only used when Congress has formally declared war. And so it kind of gives Congress a check on the use of those emergency powers before the president can do it unilaterally. Now the final question here is whether there was an abuse of discretion on the injunction. And let's see. The lower court should consider whether its grant of universal injunctions complies with CASA, that new case about how universal injunctions are put out. But that's all they're going to say. They're going to send it back down to them and say, we'd like you to reevaluate this and make sure you're complying with that, but that's all we're going to say. We're going to leave it to you to decide because we're not sure. That case wasn't out yet. So we're going to leave that up to you, but make sure that it does. So we affirm their grant of declaratory relief. The orders are invalid as contrary to law, but they're sending it back to the lower court to decide what to do with that information. The lower court's grant of permanent injunction, universally enjoining the enforcement of the trafficking and reciprocal tariffs, is remanded to the lower court to reevaluate and make a new decision. And that is where we are. So the appeal court did not reinstate the injunction. They left it up to the lower court to issue a new decision. And so that's what's going to happen now, is that lower court is going to have to go through and issue a new decision. So that's why nothing's changed yet, is because the lower court still has to do something. And that's where we are sitting at this moment. We're just waiting for that lower court to make its decision. And I think that is where I'm going to leave you. I just kind of wanted to sit down and walk through this for a little bit, and I hope that was helpful. Now, I will tell you that the dissent on this case is extensive, and I have not had a chance to go through it because it's just been a busy week. But that will also factor in when this goes almost inevitably to the Supreme Court. So they have already applied for an appeal, and we'll see what happens when it gets there. All right, well, thank you guys very much. I should be live again later, and thanks for stopping in. All right, bye guys.